Mr. Brown.
May it please the court. My name is David Brown. I'm here representing Mark Hamer on this grievance. Second time I've been before the court on a grievance case, same case. Never had that before. You probably knew a few of the facts before I even stood up this afternoon. But let me briefly go through this way. Number one, Mr. Hamer's a lawyer of long standing in Iowa City, very good reputation, business lawyer. One of his clients, who he was extremely close to for over 20 years, was Doug Paul. They were not only clients in the normal sense where he did business for him, they were very close personal friends. I think they went to the Rose Bowl together. I think they traveled on vacation together. Their wives were close as well. Very, very close. In 2004, basically, Mr. Hamer represented Paul when he sold his company in Iowa City, a learning company, for $28 million, which by everybody's calculation was a terrific success. Mr. Paul was thrilled by it, so thrilled by it that he not only paid a fee, he actually said he was going to pay a $110,000 bonus and $10,000 to the secretary because she was so helpful. Everything is kind of rolling along, and the question is, what do you do with some of the extra money to potentially invest or not that Mr. Paul had? Mr. Paul and Mr. Hamer talked about potentially doing loans, private loans, which Mr. Paul had done in the past himself, but he thought perhaps Mr. Hamer could help him effectuate some of those. And over the next year or so, I think they had 24 or 25 private loans, and over a period of time, Mr. Paul made $1 million on those private loans. Everything was copacetic between these two. They were still taking trips. They were doing whatever until 2006. So what happened? Well, Mr. Paul had an investment in two different companies called UWT and Platinum, and he put $10 million into these. And it turns out that was a criminal enterprise, flat out. The United States government came in, they subpoenaed all the records. Part of the delay in this case was a lot of the UWT and Platinum records were just taken out of Iowa City and taken to Chicago, and were part of a major indictment against some crooks who are now in federal prison. So after that experience, at some point, the attorney-client relationship ended with Mr. Paul and Mr. Hamer. And obviously there's at least some suggestion, at least from what I can read between the lines, that Paul is blaming Hamer, that he was in these investments. Except he didn't get him in the investments. Andy Meredon got him in the investments. It was not him at all. So when the complaint was filed, and you look at the complaint, which is in the appendix at volume 1, page 8. Basically, everything about this complaint is wired into the fact that after Platinum and UWT, everything starts there. This is his last chance to recover anything. He's mad about that, and he's blaming Hamer for it. When we were here before, and it was about whether we were timely in our responses, and Wendell and I joined hands on that issue, that we wanted to try the case on the merits, which we ultimately now have done. And I appreciated Wendell's professional courtesy in front of this court. But when we got to the evidence on Platinum and UWT, what did the grievance board find? What they found was, grievance commission found, no basis for that. They didn't believe what Paul was saying. Basically, he researched that investment. He called those principals himself. He had their prospectuses, and he made a decision, and he actually said on cross-examination he wasn't blaming Hamer for that. So once you get to that point, what's left?
Let's talk about what's left. One of the things the commission found, and you've alluded to it already, is this sort of double dipping on the bonus. And what the commission found was that in lieu of taking a bonus, a cash bonus, your client agreed to an arrangement that he would get, in essence, a $150,000 discount on a loan, and he would get a below-market loan. And unbeknownst to Mr. Paul, your client also marked up the bill for the sale of the company by $110,000. So in essence, he took two bonuses, and that was an excessive fee. I understand your client disputes those facts, but is there at least some, and I'll have to review the record as one of the 7 members of the court reviewing this matter, but isn't there at least some evidence in the record to support that version of events?
Not a shred of evidence supports that. Nothing. When you take a look at the complaint that was filed by Mr. Paul, there's nothing in there about what he's saying about the fee. And actually, when this came up for evidence, there's about 3 different versions of how the bonus was computed, just according to Mr. Paul. So there were some private loans, all of which were paid back. No one's ever suggesting that every dime wasn't paid back. I think there's one left where they're still paying on the tacos. But other than that, all of them have been paid off. He made $1 million on those loans. So the suggestion of double dipping, with all due respect, is, I think, Mr. Harm's theory. I don't think there's any evidence supporting there was ever double dipping. I don't think there ever was. There was a $110,000 bonus. It was added in. A check was paid, I think, for $276,000 when he got the bill. And basically, these other private loans were basically paid out over time. It was not double dipping.
2.5% rate loan to your client, that was that was just a regular transaction. That was not that was not in part as compensation for the work done on the sale.
Absolutely not. It was a theory that was espoused after everything else that the prosecution had blew up in their face. They had nothing left. And so at the end, to suggest the fee that was charged was excessive when he's able to engineer a $28 million sale of a company down in Iowa City is mythology. And I don't really know why Mr. Paul felt compelled to file the complaint, other than, at least in my mind, I think he had so much anger about the platinum and UWT that he was going to throw that out there, and that was it. By the time we got to hearing, and obviously, as Justice Wiggins pointed out the last time we were together, what took this case so long? Well, I've wondered that myself. Basically, the letter from Paul was in, I think, 2013. The complaint wasn't filed by the board until, I think, 2015. We had some health issues and other issues that kind of delayed it. We tried the case in 2017, and basically, Mr. Paul's had a lot of time to try to change his stories, and has. I mean, it's pretty clear. He's got about 4 versions of it. And in terms of the private loans, the evidence, in terms of there were 24 or 25 of them, we're in a 2-day hearing. Mr. Paul didn't call anybody. I mean, basically, he clearly negotiated the terms of every one of those loans. This is somebody that knows the detail of about every single thing he did. He's a very smart person. He's a very sophisticated investor. This is not somebody that just fell off the truck and basically says, do whatever you want with my money. That's absolutely not the case. And it was never the case. And in terms of any rate that he would charge for any loan, for the term of it, the interest rate of it, or anything else, that's his decision. And basically, Mr. Hamer wrote the documents. Mr. Hamer basically charged the person that took out the loan. He's not getting a finder's fee for it. Basically, Paul didn't have to accept or not any of these proposals, and he made $1 million on these passive loans on money in addition to the $28 million he got when he basically sold the company. So I've never seen a situation where real good friends who happen to be lawyer and friend and client and had this 20-year relationship, and somehow this thing blows up and you get this complaint filed in 2013, which as a citizen he's entitled to file, but after investigation and after a hearing, there was no evidence supporting any ethical violation by Hamer. None. Absolutely none. And I still find it really kind of incomprehensible that his reward for stellar legal work and a really terrific friendship with this individual is this type of anger and wrath that was thrown at him with no other supporting evidence at all. None. And at the end of the day, I kept thinking, they must have something. They basically just about filleted him in terms of the pleadings, in terms of the briefs, in terms of this, in terms of that. Nothing. Absolutely nothing. And
Well, you entered into an unfriendly legal environment, and here's how that happened.
an unfriendly,
Unfriendly legal environment, and that is when you have interactions with your own client, business relationships with your own client, they are fraught with ethical problems. I mean, our case law is extremely strict. I mean, we go through Mershon, Weintraub, all the cases. And we've kind of said, basically, when you have business relationships with your client, I'm gonna paraphrase a little bit, we say, well, go ahead, but we're gonna demand the highest kinds of disclosure, I mean, words to that effect. We came that close in Weintraub to saying, don't do it. We didn't, but we came within an inch of saying that.
that's how I read it.
Okay, and then, your client does a number of things. One, he has a number of transactions, with, Mr. Hamer. And then he lines up a number of transactions with other clients. We end up getting, a series of unsecured loans, even though there's some suggestion in some of them, not all of them, but in some of them that they would be secured. That's at the heart of most legal representation. I mean, when you're dealing with loans and so forth, the first thing you're worried about is security interest. I mean,
Never been a banker, don't know.
well, I've never been a banker either, but I've been involved in business transactions involving loans, and the first thing you do is establish, exhibits and documentation, and Exhibit A, Exhibit B, the mortgage, et cetera. So what we ended up with is your client entering into a very hazardous legal environment, and the disclosures weren't up to that which was required by Weintraub and earlier cases. So there's my theory, pushback. That's why you're here.
I appreciate your theory, Your Honor. I think the disclosures were there. I mean, obviously, there's a conflict in the evidence, but here's what we have in this case, which is kind of interesting. We've got Mr. Paul is found incredible in these claims that he's making about the $10 million, Platinum and UWT. In fact, the commission finds he's not credible. So then you turn around on the fee and they say, well, maybe he is credible. Well, I would suggest he's not credible on either one of them at all, none. You might have read, I assume, or you're going to read, Your Honor, do I have just a little bit to sum up here, that there's a transcript which is pretty extensive. I mean, it was a 2-day trial, but it was just these two people. Hamer had written a letter in response to the complaint that had been filed initially. And then basically there was a request for more information. He filed some other things, and he provided other things. And basically his disclosure as related in that letter, while I realize the minefield we're talking about anytime you're doing anything with a client, I think it was extraordinary. So do I think he did enough? One could say, well, should he have ever done any business with any of these people when this is what Mr. Paul wanted? I think they worked together, tandem, all the way through until the thing with Platinum blew up. And at that point, he's looking backwards with hindsight 20/20 and trying to find anything he can to basically really catch revenge. And I'm not still sure exactly why. I don't know what goes on in the human mind any more than any of the rest of us do, but I don't think there's anything here that is an ethics issue that should basically require a suspension of a good lawyer who did very good work for a client, got a really great result, got really more even after he got the 28 million, another million on these private loans, and eventually an ethics complaint, a trial, and here we are today. So, thank you, Your Honor.
Mr. Brown, thank you as well. Mr. Harms.
May it please the court, justices, Mr. Brown. My comments today will focus on some questions that this case poses, and I'm going to suggest some answers. What disclosures did Mr. Hamer need to make to Doug Paul? Well, I probably don't have them all here, but I have a few. He needed to disclose the creditworthiness of these borrowers. There were 9 loans, 8 before July 1, 2005, 1 after. That was not disclosed. the existence or non-existence of collateral. Some of the loans did say there was collateral, but what it was there any equity in it? What did you need, did it have any value? That was not disclosed. If the loans were going to be secured, and some of them were, so right on the note, Mr. Hamer needed to disclose what steps needed to be taken to create and perfect that security interest or that mortgage. And he needed to disclose whether he was going to do that work. As it turns out, he didn't, with a few exceptions. Barbara Purdy, he did provide a conditional guarantee, and I believe the Tesson Ferry Music, there was a UCC filing in Missouri. It was a St. Louis-based business. But to the extent that he was not going to complete those steps with regard to security, he needed to disclose that to Mr. Hamer, or excuse me, to Doug Paul, that wasn't done. And if you think you want to be secured, you need to find somebody else to do it, or do it yourself. Mr. Hamer needed to disclose what steps were going to need to be taken to collect on these loans if there was a default. And there was a default. The first one, 2 years in, Ted Jacobson.
Is it your position that Mr. Paul understood that Mr. Hamer was representing him on all these loans?
Yes, absolutely.
Even though Mr. Paul never got a bill, never was billed, never saw a bill?
You know, I've spent so much time on this case, I probably don't know for sure that it's in the record, but I believe it's in the record. Mr. Hamer at least billed Mr. Paul once a year in December. And so this nature of this billing, I think, was not a monthly billing situation ever. And secondly, I think Mr. Paul would have had some belief that Mr. Hamer was billing the borrower, not him necessarily. And I don't think Mr. Hamer even disputes that he was representing Mr. Paul in all these transactions.
What was the harm in these transactions? I mean, at the end of the day, I think, and I look to you to help me, but most of these loans were repaid with the exception of the UTW, of course, but
well, UWT was count 3. It was the idea of joint investments. The Grievance Commission rejected it completely. The loan that's outstanding today there is the RBA Taco John's loan in Iowa City. That loan was made in 2004, and I think the testimony at the hearing was that it'll be paid off in 2029.
Which is still owed on that one? Did that come out at the hearing?
Yes, I believe it did. I'm going to say 300, but hold on. The loan was originally for 500, or it was in 2 steps, 50 and then 450. My recollection is 300,000, but it is in the record, I believe.
And I take your point, your general point about ethical requirements and all that, but the reason for those ethical requirements is to protect the client. And here, with all this private banking, at the end of the day, even with that loan still out there, Mr. Paul actually made a lot of money. This stuff turned out really well for him.
Well,
and shouldn't we take that into account?
No. I think if you lose money or if you harm the client in some way, that is an aggravating factor. There's cases that say that. But I don't think the ethics standards should be viewed as, well, you need to comply with the conflict of interest rules unless you really stroke it. And then, well...
And I'm not saying that if my question suggested that. I'm simply saying in terms of mitigation, isn't that a very significant mitigating factor that these transactions turned out well? And doesn't it also maybe suggest that some of those disclosures, which you say were required, maybe weren't required?
Well, I think we'd be in a better position if we did not make profit a mitigating factor. I mean, these were business loans. Mr. Paul expected to make a profit. So somehow we have the idea of, oh gosh, he made money. Who would have thought? Well, that must be a mitigating factor. No, these were business transactions from Mr. Paul's point of view. He made a profit. He intended to make a profit. So if anything, it is a mitigating factor, but I really don't think that's the way we
And the interest rates on these loans were high. Some of them were very short-term. It strikes me that a sophisticated business person would have understood that there was an element of risk, and in fact, as it turned out, it was remarkably low risk. I mean, 23 of the 24 have already paid off, right?
Well, you know, this has been bandied about, the sophisticated investor. The Wintrobe case, which has been referred to, there the court specifically found that Dr. Bergman was a sophisticated investor, but nonetheless found that Mr. Ed Wintrobe had violated the conflict of interest rules. My view of this record is this is anything but a sophisticated investor who loans $500,000 to a realtor, or excuse me, I misspeak, who loans Ted Jacobson $175,000 for 2 years with no collateral. Never met the man, doesn't know anything about him, didn't see his tax returns, nothing. Well, that happened, but I don't put that in the category of sophistication. I put that in the category
But, I
of
mean, to me,
trust.
it would be a remarkable coincidence if these were all such terrible loans that somehow 23 of the 24 of them worked out. That doesn't make sense to me. If you're saying these are all such high-risk loans, they needed to be collateralized, they needed to be backed up by financial statements, it suggests that maybe if Mr. Paul was Mr. Hamer's client, maybe Mr. Hamer was doing a good job for him.
Doing a good job and complying with the ethics rules, I don't, they can diverge.
Let's get into this bonus business. You heard the discussion. The claim here that you brought, I think, is that there was like a double bonus. I'll call it a double bonus. On the one hand, you had $1 million loan at 2.5%, very, by all stretches, a very favorable rate.
No collateral.
And then you had payment buried in a $267,000, or maybe it's 287. I can't remember what it was, but buried within the fee was a second bonus, and you say it's double bonus. Mr. Brown has said, and pardon me if I miss it, but that there's not a shred of evidence that the loan at 2.5%.
In fact, there is a very good shred of evidence. It's in Mr. Hamer's handwriting. He writes on a Post-it note that the bill is $158,000, as I recall, some dollars. Now, when you look at the bill itself, which is in the record, it lists dates and a lot of things done, no time listed, no dollar amount listed, just a lot of work.
Yeah, I understand the 110 buried within the 268 or whatever it is. What evidence is in the record that the $1 million loan at 2.5 was designed to be the same bonus?
The evidence is Mr. Paul's testimony that he offered or proposed a cash bonus. Mr. Hamer says, you know what? I'd have to share that with my partners. If I get this reduced rate or below market rate loan, 3 points below what I can get at the bank, that'd be a better bonus for me because I don't have to share it with anybody. And Mr. Paul was okay with that, but then he moved away from or thought the talk of a cash bonus was off the table. We were doing the 150 basically with this loan. A couple cases to think about. We've already mentioned a few. The Willie case, 2017. The Wintrobe case, we've talked about that, 2008. The Walters case, 1999, was borrowing money from a client. The Wagner case, I think, is important, representing a buyer and a seller. We've heard about the Michon case, 1982. The Marks case, this is the good deed case. Marks buys the house out of foreclosure, says, I'm doing a good deed. The court rejected that. as a, so forth. So, we believe there's credible evidence in this record, both by testimony and exhibit, that Mr. Hamer violated 1.7, 1.8, 1.4, 2106A, and 1.102A4. This is dishonesty or reckless misrepresentation. Thank you so much.
Mr. Harms, thank you as well. Mr. Brown?
Thank you, Your Honor. It's clear that Mr. Harms and I still don't agree on anything in this case. But I want to go back, if I could, this business of a double bonus. This got made up at the time of hearing. Take a look at the complaint that this person filed, Mr. Fall filed. It's a 4-page complaint. And he presented it himself. He presented it to the Board of Ethics, and it took them a couple years to investigate it, and then they filed their complaint. There's nothing in there about a double bonus. And of course, I think the suggestion is, well, gosh, he didn't find out about it till 2010, remember, when he got an itemized bill someplace. Well, guess what? He filed this complaint in 2013. So whatever information he's got, or not, he had it when he filed his complaint, and that was not part of his complaint.
But did he testify, as Mr. Harms indicated? That he had conversations with your client about not paying him a cash bonus because that would be divvied up in his partnership and so forth and so on? Is that in the record?
Triple hearsay shots at his old law firm, the Meriden Law Firm, where Bob Downer's a managing partner. Yeah. And basically, that's pretty much what it was. And basically, Mr. Hamer totally, 100% rejected that and basically denied it. That conversation never took place. And a credibility finding on an individual who basically was willing to basically blame everything about Platinum and UWT on Hamer, and that board correctly found there's no way to give him credibility. Can't do it.
Well, sometimes they're credible for one purpose and not for another. We have that all the time.
I hadn't really seen it till this case. I think whatever was convenient for Mr. Paul, he's going to say it. Although I thought it was interesting, after cross-examination and after Mr. Hamer testified, he could have come back on rebuttal, but I think even he knew he was done.
Counsel, would we be setting a dangerous precedent, undermining our rules that regulate doing business with a client if we went along with the view that that a long-standing relationship and the sophisticated client would excuse non-disclosures?
I'm not asking you to ignore long-standing precedent. And I don't think there's anything in this record suggesting there wasn't full disclosure. And the suggestion that in any way there wasn't, again, is another myth that was spun at the time of the hearing. Because, indeed, the only thing that really comes out of it, other than I think what Justice Appel is saying, a bit of a minefield when you're doing any business transaction with any client, agreed. But remember, this was done, these private loans were done in 2003, 2004, before the model rules were adopted by this court in 2005 in terms of all the requirements.
Mershon was 82, and Mershon very unfriendly to these kind of transactions, it seems to me.
I read it just on the way over, I did, but I think it's a different universe we live in since July 1st, 2005. I do believe that.
But even before 2005, you're right, you didn't need the written informed consent, but you still had to have, if you were presenting something from one client to another client, you still had to have disclosures.
That's
and
right. And it's our testimony.
There's I guess, a dispute in the record as to what disclosures were made.
That's right.
And the commission resolved it a certain way.
Well, I'm not exactly sure how they resolved it. I think at the end of the day, they recognized there's a credibility issue, a big one, with Mr. Paul. As far as these loans, since nobody was called by the prosecution of these 24 loans as to what was or wasn't said, they've got the burden of proof. I don't. And the reality is, at the end of the day, you'd have thought they'd have brought some disgruntled lendee in to basically suggest in some way they didn't know this or didn't know that. And the evidence just isn't there. It's Mr. Paul on direct, it's Mr. Paul on cross, it's Mr. Paul's complaint, and I would really commend all 7 of you justices to look at the evolving story as to how he has this claim against his former lawyer and friend, and whatever happened to that former lawyer and friendship, which we know is gone, basically he's prepared to say whatever it takes. He wants to take him out, and I'm not quite sure where that came from. And I think this system should not be utilized that way, to basically give that kind of a harvest for that kind of a seed. At the end of the day, I think Mr. Hamer did very good legal representation for Mr. Paul. I think he did a sales of that company that I think only most of us could dream about, and I think he made him more money in these private lending. And at the end of the day, I think he should be celebrated, not condemned. That's all I have. Thank you.
Mr. Brown, thank you as well. The case of Board versus Hamer has now been submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.